Hey everybody, welcome back. It's day 4. I knew that. I definitely knew that. It is day 4, and today is law school time. Eventually. Potentially. As soon as we load. As soon as come on. Come on now. Okie dokie. This is okay. In we go. All right. I have no food or water. I have planned poorly. Okay. Let's see here. Courthouse. Right down the street. So, where can we get food right fast and in a hurry? Because it's not going to take us 15 minutes to get there. Let's see what Twitter has to. Oh. Well, I guess we're going hunting. After law school, of course. Yep. Okay. Let's see. Somebody post a menu. Anyone post it? Okay, I'm gonna risk it. I'm gonna risk it that the tavern is open. I've been burned in the past, but it's close. I can get there and to the courthouse in about 15 minutes, which is just about how long I have before class starts. Oh, it reminds me of the days of being back in college and doing everything, everything last minute and wrong. All right. Let's get our car, make like a shepherd, and get the flock out of here. Come on now. Oh, it takes so long when you have to stop at the stoplights. I knew this was going to be a thing. I knew I was going to be running behind. And I should have gotten in here sooner, and I didn't. Damn it. That's alright. Still got like 10 minutes. Whoa. What have I got on me? $155.
a Caucasian man.
What the fuck?
I didn't mean to say that out loud. That's kind of
What the fuck?
Tabby,
Oh.
insert the filter.
Well,
Hello, sir. Ignore
I mean, it's
my
true.
extremely endangered friend over there. How can I help you?
Oh, yeah,
Endangered.
sure.
Am I a species?
Can
Am
I
a
get
species? Like, what the fuck?
let's go with 2 chili dogs and 2 norms.
Coming right up.
I refuse to activate this.
Turn off the lights.
I refuse to activate this.
Wifey. Oh shit. I can't see. I can see my crotch.
Oh,
You
Yeah,
see her
that was
what?
weird. I saw my crotch. Like for a second, I sat down and I saw my crotch, and I was a little concerned. But now I can see. Turn off the lights. I'm looking for. I hate that song. You see, that guy was on crack. No. I had ice cream, wifey. That's why I'm like off the. I'm off the.
oh
jitter
my
bug,
god, you and your
Nah.
sugar.
Bro, I can't do it anymore, dude. It makes
I
me fucking a
refuse
nut.
to be jealous. I refuse.
And you knew tried this in the fucking video. Yeah, it was a good day. Fuck whatever. It was a fucking good day. 5 o'clock in the evening, skate line down my wall. Strength of 1,070 men. Really shouldn't complain.
I
Yeah,
refuse to be
You gotta
jealous.
tell
I refuse
everybody
to
I
be
love
jealous.
them.
Of course. You've been doing that a lot lately. I'm so happy.
Because
that
I
you are.
do.
I know. You've been doing that a lot. I'm so happy. You've been telling everybody you love them. It's so good. Because it's true, you do. You've been becoming more vocal about it. And people love it.
Come on, buddy, I appreciate it, but
Look
please
at that
hurry.
boy. Isn't he sweet? Has an accent. Boots to beat. He is wearing orange.
Hi,
And
sir.
Tim.
I think that's yellow. That's more of a mustard color.
It kind of looks orange
So,
to
yeah,
me. I don't know. It could be a thing. It's
Can
very.
There
you
you
do,
go. That'll be
Incognito
$60.
and funeral.
You said 360?
I remember to do that.
Yeah, we will do that tomorrow.
Sorry, I
Yeah,
didn't
nothing
catch
to do
that there.
with
You
that.
said 360, right?
Wifey, why don't you go take a seat back there?
What are you doing?
Hello?
Stop it.
What do I
Are
do?
you alright?
Are you able to hear me?
No, yeah, there we go. Hello.
Okay, that was weird. You said 360, right?
Yeah, $360 to City 89.
Okay, perfect. Hang on one second.
Sorry, I'm stuck.
It's okay.
That's bad.
Is it? Are you having trouble in here?
I'm okay now. I'm okay now.
Okay.
Thank you.
Are you okay?
Enjoy your
Yeah.
food.
Oh, thank you so very much. I'm going to be late for law school. Thank you. Okay, let's go. Okay. We'll be good. We'll be all right. I think we'll be okay. Maybe. Yeah, I got 8 minutes. Should only take like 3 to get there. Whew.
Hey, Isaac.
Hey, whew, phew, I thought I was gonna be late.
You're 5 minutes early. Howdy.
Hello.
It's going. Is the whole gang joining us, or are they just here to cheer you on?
They're here to, I guess, cheer me on.
Hell yeah. Sweet. Oh fuck. Okay, so we all injured up in here. Wait, she just got. You know, she lives her own life. She's her own woman.
Yep.
Wait. Ow.
Oh.
Yeah, I mean, as long as you weren't like running in and shouting, unless there's like shouting. It's very sweet of you. I would have rescheduled. I got into a bike accident earlier, so we're just doing great here. Twinsies. Okay. I'm going to heave my hip up the stairs.
Hmm. Oh yeah, it's all coming together.
Wait, were y'all waiting for the door's unlocked?
Oh.
I was just taking a deep breath, you know. So normally we do this in the courtroom. Normally I would stand around on my tablet. I dislocated my hip twice within half an hour today. So I am going to sit in the judge's chair and look like a big fucking nerd.
I think that's pretty fair.
In the courtroom, the acoustics are relatively fucky. Please feel free to sit wherever you would like. I would recommend sitting up here for your best listening experience, or you can sit in the jury side that we never use. Did everybody get a copy of the curriculum?
No.
I'll email you one, Denny.
Sounds good.
And that would also be a no for me.
Okay.
I guess I retrieved a copy from the website.
Great job, Isaac.
Now I just feel like the overachiever nerd.
Okay. You should now all have access to a digital copy of the curriculum. Would any of you like a printed copy?
I'm sorry, what was that?
Would any of you like a printed copy of the curriculum, or are you good with this?
I think I'm okay with this.
Okay. Same. Has everybody had something to eat or drink within the last hour? Does anybody need food or drink?
I could probably use something.
Ow. Okay.
You know, I'm good. That was part of the reason I thought I was going to be late. So
You got any food allergies?
No, I'm fine.
That is non-alcoholic, of
Thank
course.
you very much.
Stacy, Isaac, anything to eat or drink?
I know I'm
Oh.
good, but thank you.
She appears to be taking a quick nap, so we will wait and begin when she comes back. Do you guys have any questions about the legal system in San Andreas, the Department of Justice, anything you want to ask me about before we start?
No, I'm all right.
Okay, cool.
Welcome aboard.
Hey, M. Keevers, thanks for the follow. Ooh. It's very bold artwork in here.
Very what?
Very bold artwork.
Indeed. Yeah, it's, it really sets a mood.
I am having a blast so far. Isaac is very confused, very lost, and has no idea why he's even doing what he's doing right now, but he'll figure it out. Maybe. Unless Barfo drives him insane, which is also a distinct possibility. As I violently clip through the chair. Well, yeah, well, Isaac is so Isaac is a very isolated person. He's really inside his own head, and so kind of his backstory forcing him to come to Los Santos and have to like start over in a sense is kind of overloading him to begin with. And then you've got Los Santos itself really taxing his ability to like grapple with the situations presented to him. This is the exciting part about live streaming. Sometimes you're just sitting in a damned room with nothing going on. How do you comment on this? It's lovely chandeliers, and the paintings are a choice. I feel like there's probably... So, like, 4 of these look like they're maybe stock artwork for this room. I'm not sure who did these other 2. I mean, they're really well done. I don't know if they're like server fan art or not. they they definitely set a mood for the room, that's for sure.
Okay, it appears I've gotten an email from Stacy that she isn't going to be able to join us.
Oh, okay, cool.
She's having trouble waking back up, as it were. So let's go ahead and start if the 2 of you are ready.
Yeah, of course.
Sure, I'm ready if you are.
So first, I'm going to go over the general rules of procedure and goings on for the courtroom, just to kind of give people an idea of what goes on here. The state of San Andreas generally holds bench trials. These are watched over by one judge. We also do have hearings and other, types of court. Generally speaking, we're not going to see jury trials because the population in the city is so low and news travels so fast that it would be hard to get an impartial, unbiased jury on pretty much any situation. We are making progress on getting a court of appeals together as well, in case somebody ever does oppose the judgment given to them in court. We'll get there when we get there. Generally speaking, for court, you do want to make sure that you are well dressed. I usually say shoulders to knees. If you can cover your tattoos, please do. Just in case you think that they may be distracting or they may contain something offensive. Obviously, I'm normally in suit pants, but I dislocated my hip twice within an hour today, so we're doing pants. And of course, tattoos on the hand, face, or neck are generally acceptable as long as they are not vulgar or offensive. In the courtroom, you are going to
I
want
want a
to make sure
lawyer
you
with a
are
face
shouting
tattoo.
because the acoustics in here are
I want
wacky.
that to be a thing.
And of course, if you are representing someone in court or you are the party to a court case, don't be talking shit on Twitter. Try not to be on your phone unless you have to be in court. If you are found to be, talking mad shit on Twitter, it would be the same thing as sitting in the gallery during the court case and talking shit, and you may be served with contempt of court. Okay, with those basics out of the way, let's go ahead and start with some Latin terms.
Seriously?
Ex parte is, of course, in the interest of only one party or one side to a case. And for that reason, counsel from either side of a court case is forbidden from meeting with the judge to discuss the case without the other party being present. This would be if you two were the attorneys on a
Nice.
case. Isaac comes up to me and he's like, "Hey, Darian, how do you think it would go over if I did my case this way?" That parte. Damien is not there to hear viewpoints. Damien is not there as a party to the case. And if I were to give you that information, it may give Isaac an unfair advantage. Generally speaking, if you do approach the judge on a case and start talking to them about it, generally speaking, we just walk the fuck away. Or we'll tell you to knock it off or whatever. The exception to this, of course, is if you have evidence that you don't want to be available to the public, like somebody's medical records or psych evaluations, but that you do still want to be included in the case,
Let's
you
change
could
this
use the
emote.
judge
He's
to
wiggling way too
facilitate
much.
making that available to parties to the case, but nobody else. Or you, of course, could reach out to the judge for scheduling or other very basic questions like that. In forma preparis is, of course, in the manner of a pauper. That allows anybody to bring a lawsuit without having to be liable for the costs of the suit until the suit is completed. Normally, this probably makes you think, of course, your Miranda rights, like you have the right to an attorney. If you cannot afford one will be provided to you. But this actually also covers civil cases. You can bring a lawsuit and bring civil liability on somebody, even if you are concerned that you may not be able to afford a private attorney. Our public defenders don't and public prosecutors don't necessarily cover that. However, anybody should be able to bring a lawsuit in the state of San Andreas. Prima facie is at first glance. We generally refer to this in terms of torts. And it's, the very basic first glance things that you can identify about a situation.
My God, it is so hard to
We
be
will talk
serious
about
right
it
now.
more when we get to our civil torts. Per se is of itself or intrinsic. That's like a common phrase. I feel like people use it in actual conversation.
Smathers is in
Pro
town.
hoc vice is
That'll
a
be
for this
interesting
occurrence.
later.
Essentially, this is if somebody comes in from out of state and they find themselves needing to appear in a court of law, but they don't have a San Andreas bar license and they don't have the time to go to law school, they can go to a judge and be like, hey, I am barred in, Empire State and Liberty City. Can you please give me a for this occurrence law license so that I can represent my client? And I think we've had one or two cases of this. It's not super common. Pro se is for yourself and on your own behalf. When somebody proceeds without legal counsel and decides to represent themselves, they are proceeding pro se. And of course, anyone who represents themselves has a fool for a client. Even if you are a lawyer, even if you think you are the best damn lawyer in town, get a lawyer. Like, at worst, they're going to be there to support you during like evidence collection or even just there for moral support. At best, they can help with questioning, they can provide objections that you don't immediately think of, and they can make you win your case. Res ipsa loquitur is the thing speaking for itself. This is generally used in reference to res ipsa loquitur negligence, which we will talk about in our civil torts. The res gestae of a case are all of the events, circumstances, remarks, and evidence that relate to a particular case. That includes, of course, your witness testimonies, your evidence, your records, your oh my god, what is the word? Affidavits, etc.
For anybody just
Mens
wandering
rea
in,
and
we're
actus
in law
reus.
school. It's gonna be thrilling.
The mens rea is the intention or knowledge of wrongdoing that is part of a crime, and the actus reus is the action or conduct that is the element of the crime. So your mens rea is going to cause you to perform the actus reus. It's the difference between murder and involuntary manslaughter. You might accidentally run someone over with your car and kill them. But if you premeditate having them go to that point at that time and you make sure to put extra equipment on your car and drive very, very fast with the intent of killing them, there would be a difference. The mens rea was different. Obviously, if somebody knows what they are doing is wrong, it is part of mens rea, even if they don't particularly intend to do it. But different mens rea, different crimes. Next, we will go into some of our basic doctrines and law stuff, or rather law stuff that the PD deals with a lot.
That old technical term, law
The
stuff.
plain view doctrine. Law enforcement officers may examine and use evidence that is visible to them if they are in a location they are legally allowed to be in. Somebody is giving me a call.
I'm literally.
Hi, I am in law school. Is it an emergency? Hi, I'm in law school. Is this an emergency? It's okay. Can I call you back when I'm done?
when the prop animations screw up and you're answering your call on a tablet.
Sorry about that. The plain view doctrine basically says that if you have a big baggie of Coke on the seat of your car and they are on the sidewalk, you have your window down, and they see the Coke in the car, they are legally allowed to use that as evidence for you having possession of Coke. And they haven't technically searched your car. If they can see it through a window, through a bag, if you have something that you are openly carrying, they are on public property or somewhere where they have the legal authority to be, they have not completed a search and they are still allowed to use it as evidence. Reasonable suspicion is the belief based on facts that there is criminal activity afoot and further investigation is needed, whereas probable cause is that there is sufficient evidence to conclude that somebody has committed a crime. The reasonable suspicion is the law enforcement officer gets a call over their radio. An individual with white hair, limping on crutches, wearing a houndstooth printed skirt, was seen leaving the site of a Fleeka bank robbery. We believe they may have been involved. And they see me hobbling away from the Fleeka bank. Maybe I wouldn't have a gun out or a bag of money or anything like that, but they can have reasonable suspicion I was in the area of the crime, matching the MO of the criminal. However, probable cause would be if I were, speedily crutching away. I have a comically large duffel bag full of money somehow
speedily
over my
crutching.
shoulder. It's partially unzipped. The dollar bills are
Want an
flying
excuse
out.
to use that term now.
I'm
Speedily
saying that you're
crutching
never
away.
going to catch me alive, etc., etc. They would then have probable cause to believe that I had in fact robbed the Fleeka. And they could stop me and potentially detain me for the crime. With reasonable suspicion, they can perform a stop and they can question people. But it's advised that obviously law enforcement
Excuse
officers
me,
don't
sorry.
detain you unless they have probable cause to believe
Yawn out of
that you
nowhere.
have committed a crime. The transferred intent doctrine. So this is when somebody intends to harm one person, but unintentionally harms a second victim instead. This is only for crimes that are actually committed and not like, oh, I don't even know. It's weird because it's hard to explain the completed versus attempted, but essentially, let's say that I have gone off my rocker and I have decided to murder Damien Summers with a crossbow. Isaac, you step in front of Damien because you see the wild look in my eyes and you wonder where I've gotten a crossbow in this city. And, I'm trying to aim for Damien and I fully intend, I have the mens rea to shoot Damien with this crossbow. Unfortunately, even as you dive out of the way, Isaac, my aim is shit, and I hit you instead. The mens rea and intent that I had to shoot Damien with that crossbow would then transfer to the crime that I completed on Isaac. Even though I didn't mean to hit him, he was hit. Double jeopardy. Also, are there any questions so far? I feel like it's pretty straightforward.
No, I'm good.
Any comments, complaints, criticisms?
No, I think it makes perfect sense, though. With the diving, is Whitney Houston music required or optional?
Optional. Highly recommended.
Okay, good.
Double jeopardy is, of course, part of our Fifth Amendment rights under the Constitution of the United States. No person shall be subject to the same offense to twice be put in jeopardy for life or limb. Essentially, a person cannot be charged twice for the same incident. They can be charged for multiple counts of the same crime if, they committed the same crime multiple times on different subjects during the same incident. But once somebody is tried once or charged once for an incident, law enforcement officers and the courts cannot go back to that same incident and change or resubstantiate the charges. It's one and done, and that's why it's very crucially important for our law enforcement officials to get it right. Because if they give somebody the wrong charges, the person goes to court and they get overturned, they don't get a second shot. With opening and closing statements, I'm going to go over a brief overview of a court case. Congratulations, you two are lawyers. You have been selected to stand in a court case. Just going by the seats, Damien is the prosecution and Isaac, you are the defense. First, before we even make it to court, we would go through our discovery period. Any evidence that, especially detailed
change the view
evidence
up a
or
little
like
bit.
body cam footage, would be submitted prior to the trial, ideally. You all would interview all the witnesses and gather your ahead of time, and we would schedule a date. Make it to court, I ask, you guys doing good? You ready
For anybody
to
just
move ahead
wandering
with
in,
this? You would say
we're
yes. We begin court.
we're in law school,
The
so
first thing I'm going to do is
it's
I'm going
not
to
a
ask
whole
if there
lot.
are any
Not a whole
preliminary
lot.
motions that need to be presented before the case starts. This would be if, Damien has a slam dunk case to just, or rather, sorry, that Isaac has a slam dunk case to knock Damien's case out of court, or Damien wants summary judgment because he believes that the evidence he has is just so massive, numerous, and legit that we don't even need to have the trial. Any motions for summary judgment, dismissal, things like that would be brought up prior to the case beginning to save everybody time. However, you can also make those motions at any time during the case if you believe that they apply. If there are no motions or they don't succeed, we would move to opening statements. The prosecution would begin with their opening statement, which is, if you were writing an essay, it would be the thesis statement. You want something that's not especially long, you don't need to include evidence. You're going to explain concisely what you are trying to prove. We are going to show that the defendant is guilty of this because this.
Oop,
Here
oop.
is their mens rea,
I'm bumping everything.
and they did this actus reus. Pretty much that simple. Afterwards, the defense has the option to present their opening statement, but they can also present it at the beginning of their witness questioning. Generally speaking, they just do it at the beginning, though. After opening statements, we would begin our direct questioning and evidence presentation with the prosecution. They would call their witnesses, submit police reports, other documents, anything that they need to prove their case. And the prosecution would do the direct questioning, which is, where were you on the night of May 12th? And what were you doing? Could you please tell me what happened? Those sort of open questions. Then, once the prosecution is done with their questioning, the defense would get a turn to examine. On cross-examination, lawyers are generally expected to only ask questions pertaining to what was covered in direct examination. If they need more details or they know other things to ask that were not covered, they would then pull that same witness for their direct questioning. However, nothing's stopping you from asking that question other than objections from the prosecution. Fucking words are hard today, the prosecution. And in cross-examination, you are going to lead the witness and twist their narrative to suit your story. After cross-examination, the prosecution will get a chance for redirect. And on redirect, they can ask more clarifying questions regarding what was covered in cross-examination. Once one side has exhausted all of their witnesses and presented all of their evidence to their happiness, the other side will get a chance to pull up their witnesses and do their direct examination, provide their evidence, etc. Once everybody has all of their evidence on the table, we would move into closing statements. If the opening statement was your thesis, the closing statement is going to be your conclusion paragraph. This is where you are going to bring in your evidence a little bit. You're going to be like, I can show that, this evidence showed that they were there at this time, they left this behind, they were seen by these witnesses doing this, therefore they did it. Or, probably something better than that and more related to any particular case. And after the closing statements, the judge or jury, but mostly judges, will deliberate and present their verdict.
Just
In a criminal case, that would
grabbing a
include
pen.
any charges that the subject is guilty of. And in a civil case, it would be the judgment and damages awarded to any one side of the case. Which brings us to merger. Merging things, obviously, is uniting them. In corporate law, that is when one company buys another one and sucks it up in there. Like when PDM merged with Auto Exotic, and now they have the two vendors.
When two
within the
corporations
building.
love each other very much.
In civil procedure, it's this idea that the final judgment at the end of the case brings together all of the claims involved in the lawsuit. Because of that, the plaintiff can only enforce what was awarded, even if in their plea for what's the word? Oh my gosh, I'm blanking on this. I'm sorry. Their prayer for relief. They asked for $100,000, including punitive damages, missed work, etc. The final judgment was for about $50,000 and didn't include those punitive damages. Even though the plaintiff wanted those damages, the final judgment lumped together all of it, and that is the only amount that they can ask the other person for or make sure that they deliver. In criminal law, it's a little bit more complicated. The idea is that in the merger doctrine absorbs the lesser included offenses into more serious offenses if a defendant is charged with both in the same incident. So let's say again that I am a horrendous criminal. I postured up on Damien like I was going to hit him, and that was assault. And then I pulled out a bat and I kept doing it, and that was aggravated assault. And then I finally, gave in or whatever, and I started beating him with the bat. That was battery. I continue beating him until he falls and is downed.
It feels a little on the
That would
nose,
be
doesn't it?
aggravated battery. Once he is downed, I continue and I am trying to murder him. It would be attempted murder. And obviously, while I did commit all of those things to Damien for no ascertainable reason, sorry, Damien.
Uh-huh.
I'm gonna use Isaac as an example too. I just know you better, so I feel more comfortable.
No, you're fine.
Obviously, while I did do the assault, the aggravated assault, the aggravated battery, and the attempted murder, and maybe even the murder, who knows, I would only get charged with the worst one of those because it was a progression. However, this is again where we go back to multiple count. If I postured up on Damien like I was gonna fight him, and then I turned and I beat the ever-loving heck out of Isaac, I would still have that assault charge on Damien, but I would also have the battery on Isaac. The only time where merger starts to get weird and you don't get as much absorption is when the felony murder rule is in play, but we will get to that after hearsay. Any question?
No, I'm good so far.
No,
And
surprisingly,
obviously
this makes a lot of
in
sense.
property and contract law, it is the idea that something lesser is getting absorbed into something larger. Or in contract law, it can also be the modification of a thing absorbs anything previous and potentially even supersedes it. So hearsay is not just an objection, it is the idea that there's information that cannot be adequately substantiated that maybe somebody heard from somebody else. It is the he said, she said. It is me going up on the stand and going, well, I heard that Arden said that Vinny said that this happened. That's cool, that's hearsay, that is not the truth of the matter from me. They would have to call Vinny up on the stand or Arden up on the stand to get that direct witness. And it should be objected to and or stricken from the record. However, if it was the he said, she said, but it dealt with the present sense and impression of what had happened, the way somebody was acting, the way somebody was feeling, something that somebody excitedly uttered under the stress of a situation, that would be an exception to hearsay. If he was, if somebody was being treated at Pillbach and they made a statement for medical diagnosis or treatment, somebody overhearing that would not necessarily count as hearsay. Or if I came up and I read, Vinny's diary, it is a recorded recollection, and while I was not present for it, and I could not adequately substantiate whether or not it was true, it is a written record. And not just journals. Of course, you got like your birth certificates, death certificates, marriage licenses, business records, transaction logs, or the absence of those when there is normally one. So if somebody is on court for embezzlement and, their accountant keeps meticulous books, but the records for 1/4 are not right, or they're missing, or they're damaged, that may be evidence in and of itself. And of course, any documents that were created by a religious institution or other organized system that's not just the state of San Andreas do still count. And reputation and, what's the word? Yeah, I guess just reputation and like previous judgment can count. Like if somebody has a reputation for, say Tom Grizz, has a reputation for shooting cops. And if somebody came up and, was talking about how they believed that Tom was going to do something because of this reputation, it would not necessarily be hearsay as long as they could substantiate that reputation. Or if it is like a personal or family history thing, like knowing that I was previously married to Dirk and Cece. Or if there was a previous conviction, if somebody was convicted for, 10 different types of traffic tickets, and they came in to like contest a traffic ticket and tried to say like this isn't something they normally do, but the prosecution could establish that it in fact is something they normally do, it would be an exception to hearsay. Okay, the felony murder rule, which is kind of a complicated concept, but kind of easy. Essentially, it allows a defendant to be charged with first-degree murder, which is to say premeditated murder. I believe it is actually first-degree manslaughter in our penal code, which doesn't make any sense. But we got a new state council coming in, we'll work on it. Essentially, you can be charged with premeditated murder for a killing that occurs during a dangerous felony, even if you are not the killer. Let's say that we have decided to become criminals and we are doing a Fleeca bank robbery. We go outside, Rory goes along with us, we kidnap Reggie. We take Reggie to the Fleeca and we're holding him hostage, we've got the gun pointed at him. I'll say that I'm holding the gun so as not to put anybody at any sort of risk. I'm holding the gun to Reggie's head, the police look like they're gonna breach. I shoot Reggie. Reggie dies. While I didn't have the mens rea to murder Reggie, because we had taken Reggie and like kidnapped him, and there was a dangerous felony of robbery going on, all of us who committed the Fleeca bank robbery, which would be me and Isaac and Damien and Rory allegedly, could be charged with the premeditated murder. Because while we didn't premeditate Reggie's killing, we premeditated the inherently dangerous felony of kidnapping, of robbery. We knew that it could, it could hurt people. People could die. And obviously we weren't being recklessly indifferent to Reggie's life. Generally, people who kidnap people and use them for robberies don't actually want to kill them. They just want the money. And we didn't really intend for him to die, we just intended to shoot the hostage. Doesn't matter. However, if the elements of that felony, so be it whatever it is, are part of the elements of the murder, we cannot apply the felony murder rule there. So if we've kidnapped Reggie for the Fleeka Bank, and you guys are helping, blah blah blah, and then I get it into my mind that I am going to burn down the Fleeka Bank, and I do an arson, and you guys weren't involved in the arson, but the arson kills Reggie. I charged with that murder, but the other people associated not.
Oop, sorry about that.
Or because if I had, assaulted him, and that was what led to his death. I guess that's a better example, as if, like, not part of the robbery, I beat Reggie up, and Reggie somehow dies from those wounds. It would not be a distinct crime, because it would merge into the murder and not the other thing. And it would not be a felony murder situation. Any questions there? I feel like I kind of got muddled.
No, I think I get it.
Okay, so let's talk about RICO, which is to say we don't really talk about RICO in this city. It is the Racketeering and
So RICO
Criminal
is Fight Club.
Organizations Act.
Okay.
Or what is the actual acronym? Sorry, the Racketeer Influenced and Corrupt Organization Act, to eradicate organized crime. So this is a huge case. This is, kind of a huge fucking deal. And to bring one of these to trial, you would need years of evidence of the individuals that are part of a criminal organization. Not just the organization, like, if we were talking about the Leone crime family in Liberty City, you would not be able to name them as the defendant, but you would be able to name, like, Sergio Leone, etc., etc. Otherwise, it would not be legally sufficient. They would have to show a pattern of racketeering activity, which is to say, drugs, prostitution, extortion, robbery, bribery, fraud, obstruction of justice, crime shit. You have to show a substantial period of time in which they are
The technical
continuously,
term of
regularly doing
crime shit.
related acts of crime as part of a
Crime
criminal
shit.
organization.
Noted.
The burden of proof for these kind of cases, whether civil or criminal, is frankly obscene. And very few of them make it to court, even less so in the civil way. So you're going to want to reach out to a judge or the DA's office, depending on whether you're going civil or criminal, before you even try to bring one of these to court, because frankly, we don't want you to waste your time, and obviously we don't want to waste the Department of Justice's time either. In civil court, let's go ahead and bring up those torts and their prima facie. Before I do that, though, any questions on RICO?
No, definitely have had issues with that previously. So.
Oh no, I'm sorry, Damien.
No, it's fine. Just used to it.
Okay, so torts. Some of these look about the same as crime, and that's because they are. These are just the crimes that you can sue for. Trespassing. The defendant had the intent to invade the plaintiff's land. They did so. The plaintiff owned the land and did not give their consent to the defendant, or did not notify the defendant, or rather told the defendant that they could not go on the land, and the defendant did it anyway. Pretty straightforward. Of course, now we have assault and battery. Assault, the defendant acts intentionally so as to cause the plaintiff to reasonably expect harmful or offensive contact. This is to say, like, you're not afraid that necessarily that they're gonna fight you, but you have a feeling that they're gonna fight you, or attack you, or do something to you that you don't want to have done. Assault. Battery, the defendant acts to cause a contact with the plaintiff that the plaintiff does not consent to, and that is harmful and offensive. and they do it. This is, of course, obviously like the basic beating somebody with a bat, but it can be something as simple as if I were to hop out of this chair, hobble over, and just knock Isaac's tablet out of his hands, move his laptop, maybe push him around a little bit. I may not have caused that much harm to Isaac, but it is a touch and harm that was intentionally done to be harmful and offensive to Isaac, and he did not consent to it, probably. False imprisonment. The defendant willfully acts to confine the plaintiff without their consent and without the authority of the law. They do so, causing the plaintiff's confinement, of which they are aware. So essentially, if I were to somehow herd the two of you into the judge's office and lock you in there, I don't have the legal grounds to do so, and I sincerely doubt that either of you would consent to that, although we do have a very comfortable chase lounge.
Or that
It
I
would
might.
then be false imprisonment. The intentional infliction of emotional distress. The defendant acts to cause the victim emotional distress so severe and so bad that it could reasonably be expected to adversely affect somebody's mental health. They act outrageously to do so, and they do cause that distress. So this would be, I mean, it's another one of those that's going to be really hard to prove in court.
Again, anybody just
We'd have to
wandering
prove
in,
that
we're in law
defendant
school,
acted
so
intentionally again
it's gonna be a little dry
and
for a
did
while.
things that are so horrible and so bad that it caused the plaintiff to have that, severe emotional damage or adversely affected mental damage. The kind of thing that, like, it sends somebody to therapy. This doesn't get sued for a lot, and when it does, again, it's a burden to prove that the conduct that happened was outrageous. So we got 3 forms of negligence. Obviously, there are more, but here is the 3 ones. We've got our plain old vanilla negligence. The defendant owed the plaintiff a duty of reasonable care. They breached that duty. The plaintiff was injured because of it. Let's say you are a member of the San Andreas State Trooper. You have a suspect cuffed and you put them in your vehicle. You tell them that you are taking them to MRPD to be questioned, booked, and eventually transported to Bolingbroke. You owe them the duty of reasonable care of getting them there because they are handcuffed and cannot reasonably, do for themselves. Unfortunately, in your hurry to get them into the car, you cushion their head, you get them in there, but you forget to buckle their seatbelt. And because the way they are cuffed, they can't reach and do it for themselves. On your way back to MRPD, you're driving normally, but a local pulls out in front of you. You smash into them, and the plaintiff, because they are not buckled in and don't have the seatbelt to stop them, smashes their little face on the metal divider between the front seats and the back seats. You would be negligent and cause that injury because you did not perform your duty of reasonable care and buckle them in. Negligence per se. So this hapless plaintiff has made it to Bolingbroke. And the statutes and administrative laws in Bolingbroke create a duty of care to provide food and water to their prisoners because they cannot get it elsewhere. The plaintiff is a prisoner and is therefore in the protected class. However, Bolingbroke decides that they are shutting down the kitchens, nobody can have any food or water. Basically, go fuck yourself, go look for crumbs. Try and see if you can get somebody to throw you a bag of chips over the fence. Because they are violating the rules and the
feel like
duty
this
of
already
reasonable care that
describes the
they've
US prison
established
system.
to provide food and water for the prisoners, and they have the rules there to stop people from starving or dehydrating. If our hapless perp was to then starve or dehydrate and need medical care or be injured because of it, it would be negligence per se. So res ipsa loquitur negligence, we're going to go into a new example, but the plaintiff needs to prove that this is the kind of thing that doesn't happen without negligence. The defendant was solely in control of the situation, and the plaintiff didn't contribute to it. This is construction accidents. Somebody misuses construction equipment, doesn't follow the weight limits or the safety standards that have been put into place to use the instruments properly, and they cause an accident that harms somebody who wasn't involved. They have a crane that they are using to airlift a piano into somebody's, 12th floor loft. They have these weight bands and tension, what are the thingies, the straps, the tension straps, to hold the piano up as they lift it into the window. The piano, I don't even fucking know how much a piano weighs. Let's say a ton. The piano weighs a ton, which is 2,000 pounds. The straps are only weighted for 750 each, therefore being a total of 1,500 pounds. They decide to put the piano on 2 straps anyway and lift it up into the window. Unfortunately, the straps get overloaded, the piano falls, and comically hits somebody below. Or hits the ground, breaks, and the shrapnel hits somebody. The plaintiff, or the people that were operating the crane and that strapped up the piano, would be potentially, liable under res ipsa loquitur negligence, because if they had used the tension straps and equipment properly, and were not negligent in making sure that they were using it properly, the piano would not have fallen. Private and public nuisance. So, private nuisance. The defendant is not trespassing, but it is an intentional activity that happens more than once, let's say on a recurring basis, and interferes with the plaintiff's right to use and enjoy their land. So, you live out north, and you have a neighbor. And every day around 12:15 p.m., you're getting into your work groove, you're getting stuff done, or you're just trying to enjoy your fucking life. Your neighbor decides to loudly blare WWE fights or MMA fights. It's pumping. All you can hear is people cheering, the sounds of people fighting, maybe even some shouting and commentary. And it is so loud and so distracting that you can't reasonably do anything. You can't work, you can't read a book, you can't have peace. And they do it every day. They are being a private nuisance to you by regularly and recurringly doing that. Public nuisance. This is when somebody interferes with somebody's right to use the public, but does it to single out a person. I have suddenly decided that Isaac can never go to the library again. Isaac decides that he now wants to go to the library. In order to stop Isaac from getting in, I take my Corvette and I park it in front of the library doors. It is an injury to the public because now nobody can get in, but I am doing it specifically to stop Isaac from using it. I am being a public nuisance to Isaac and also probably getting a bunch of traffic violations. But public nuisance. Alright, product liability. The defendant sells a product the plaintiff uses. When the defendant sold the item, it was defective, whether they knew it or not, and the plaintiff was injured by the defective product. Even if you don't know an item that you are selling is defective, you can still be liable for the injuries caused by it, especially if it can be proven to have been defective when it was sold. Inducement of contract. The plaintiff has let me just make an example. I have made a contract with Damien that I am going to go to his lawn at his house every Sunday, and I'm gonna mow that bitch. I'm gonna mow it so good. Isaac overhears me making this contract with Damien. Now, Isaac doesn't run a lawnmower business or anything like that, but he decides that it would be really, really funny if he showed up half an hour before I was scheduled to go to Damien and mows Damien's lawn. Because the lawn is already mowed, I am no longer able to fulfill my contract with Damien. I am caused financial harm, and Isaac didn't really have a justifiable reason to stop me from fulfilling that contract. That said, I'm not gonna mow your lawn, Damien. Sorry.
That's fair.
It-
That's fine.
And I'm just a random nice guy, so I might just randomly mow your lawn. So
Yeah, he might mow your lawn.
You might. I would be concerned at this point if you know where I live, but
well, I mean, I would be mowing a random lawn. It just could be yours.
that's okay. That's fair.
He really is just that nice. Usually this is where I take a brief recess and drink a bunch of water. Is everybody good to take a 5? Well, we'll do a 10-minute break because that'll put us at the top of the hour.
Yeah, sounds fine to me.
Awesome. So after the break, we will do case law and objections, and then it'll be time for the test.
Sounds good.
See y'all back here at the top of the hour. Yeah, these chairs are cursed, all of them.
Yeah, just a little.
All right. Here we go. What is Isaac doing? His break? He reads. Well, that's definitely not right. Yeah, that's not it either. There we go. Now he's actually sitting in the chair. He's not sitting on the chair. All right. Woohoo! We're gonna go hunting. I think, maybe. We'll find out. What's going down on Twitter in the past? Let's see. Fight. Ooh. Nice. I think I'm... Yeah, I don't remember if I'm missing all the windows in my car or not. I can't remember if I got them fixed. Oh, tavern's closed. Tavern's always closed. I'm like shocked it was open before I had to come in for law school. More pictures of me on Twitter. Just random ones. Oh, people are liking them though. Can I see who liked them? We'll just respond with that. Oh jeez. Oh jeez. Yikes. I've never seen Granny Smathers up close. That is a choice. Yikes. What the Okay. Hmm. You know, I know this is an Ami thing. I've never had the marshmallows. I'm gonna have to chase down Ami and be like, hey, Mirror Park Tavern always says you got marshmallows. What are the marshmallows? Alright, I've got my notepad. Let's get in there and school some law. When... Okay, well, when Darian goes back, we'll go ahead. I gotta set these to automatic somehow. So for anybody who's just wandering in, we're on a brief break from law school, and we're about to finish up and, I guess, take the bar exam? Question mark?
Yeah. Why does everything in my life have so many goddamn stairs involved, though?
Yeah, I noticed that with a lot of places that like they're not as handicap accessible as they probably should be.
You know, that almost feels like a philosophical statement.
I guess it could be if you want it to be.
You just have to find somebody willing to sue. Okay, is everybody ready to continue? No need of food, water, sunshine, etc.
Yeah, I'm good. I actually did have a question.
I have an answer.
Regarding the tort law and trespassing. So I know there's been a precedent set with trespassing, I believe, where it doesn't actually count until somebody tells you to leave the area first. Right?
Generally speaking, yeah, I think in San Andreas, it's like somebody has to tell you to leave their private property before you would have to leave it or it's trespassing. Because of the way that public versus private property works in the city, it can be hard to tell sometimes. But that's also like criminal trespass. And if with civil trespass, it can be a little bit more petty. Uh, but yeah, you do want to establish that the defendant is aware that they are trespassing on private property and they do not have permission to do so.
Okay, so yeah, it's so somebody could step on a private property. They're not technically trespassing until they're told to leave first, and then if they still refuse to leave, then it's trespassing.
Yeah.
All right, got it. Yeah, I just wanted to clarify on that.
Okay, cool.
So,
Before I go
I
ahead,
was just going to say, if I could like piggyback on that. So, hypothetically speaking, does that mean that signage that would claim no trespassing is not defensible because it isn't a verbal notification?
Yes and no. If there are signs posted or other notices posted in easily visible places and you can prove that somebody did see a no trespassing sign and decided to continue, they could be civilly liable. It would just be a matter of like, how are you going to prove it?
Okay, sure. So it's the burden of determining that they actually were able to see the sign and were made aware of the situation.
Right, because I believe some of the construction sites in town have treasure boxes. There's one actually across the street at the construction site from here. There is no publicly visible sign that it is property and there's no trespassing between the entrance to that construction site and the treasure box. Therefore, if that company wanted to say, like, what, people have been trespassing on our property to get at, the gold coins or whatever the fuck in the treasure box, it could be argued that people were not aware that it was, private property and not a no trespassing place, as there is an open fence and easily accessible ladders and no signage indicating otherwise. But also they could prove that, they make it pretty obvious. Which actually brings me into the standards of proof for civil and criminal court. For a civil case, like with trespassing, it is on a preponderance of the evidence. This is to say, one side is more right than the other, 51 versus 49. And of course, the amount of evidence that there is a preponderance of would also determine the amount of damages in a situation. However, criminal court, you are innocent until proven guilty beyond a reasonable doubt. The judge needs to be 99% sure that you committed the crimes to give you the time. And if, a case comes up and we can't prove that somebody committed, 2 acts of battery, but we can prove that they committed 1 act of battery and 1 act of assault, they can be sentenced to be guilty of that and not the crimes that they were originally charged with. So there's our standards of proof. Now, to file a case, if you are a public defender and somebody wants to file a criminal appeal, you are going to go on the government website and file the criminal appeal form under the DOJ forms. And then a public prosecutor or a member of the DA's office, depending on what's going on with the crime, will file a criminal complaint form and the case will begin. For a civil case, if you are representing somebody who is suing somebody else, you are going to go on the government website and file the complaint for a civil case form. This form, we are working on getting new forms into the system, I believe, but the civil case form not only includes lawsuits, it includes somebody has unfortunately passed away and you need a hearing to determine the legality of their will. That would be a civil case form. Any form of hearing, property rights, anything like that is going to be on that complaint for a civil case. And once that civil case is filed, the court system or the attorney, depending on who feels comfortable doing it, obviously, if you are the plaintiff or representing the plaintiff and you can contact the defendant to let them know they are being sued, that is appreciated. If you don't feel comfortable doing so, it would then be on the courts to contact them and let them know to get legal representation. And we would proceed, of course, with the whole court system that I've already explained. And again, for RICO cases, please contact the DA's office in cases of criminal law or criminal RICO, or a judge in cases of civil RICO prior to filing the case or ideally even collecting all of that evidence. Which, okay, so now we are going to talk about some case law. Damien, this may be familiar to you. These are some pretty common case laws that are frequently used by our law enforcement officials. Let's start with Miranda versus Arizona from 1966. The subject must be read their rights if they are both in custody, that is detained, and being interrogated or questioned. And if they are read their rights, spontaneous utterances prior to that can still be used and are still are still admissible in court. The Miranda rights go as follows. You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided to you, at which point a cop will generally ask you if you understand your rights as they have been read to you, and ask you if you still want to speak with them. If you get arrested and you are being detained, don't talk to the cops, talk to a lawyer. Get a lawyer. It's just that simple. You don't have to speak to a law enforcement official. Obviously, you do want to try and be polite if possible, just given the situation. But you don't have to be, and you don't have to fucking say anything to them if you don't want to. And if they do hard cuff you, keep you in a situation where you are aware that you cannot leave without it being a legal issue, you are being detained. And if they start asking you questions that are more detailed than, like, how are you feeling today? Isn't the weather nice? Or are related to an ongoing
The
crime,
literal moment when you can ask, am I being detained?
they better read you your rights or it's going to be an issue. Mapp versus Ohio, colloquially known as the fruit of the poison tree. Evidence that has been illegally obtained during investigations is inadmissible in court, and any further evidence that stems from that illegally obtained evidence is also inadmissible in court. If the police perform an illegal search of a vehicle and find information that links them to, you know, a big drug trafficking warehouse down by the docks, they go to that warehouse based off of the tip from that illegal search, and maybe they even get a fucking search warrant for it. But because the initial search that led them there was done illegally, not only is the stuff they found in the car inadmissible, that whole warehouse situation is also inadmissible and cannot be used. We recently, I believe, had a hearing for the admissibility of some evidence in a case. And because an interrogation was done illegally, a whole bunch of evidence was struck from the record.
I'm just bumping into
Um,
everything today. Jeez.
Obviously, neither of you are law enforcement officers, but if you are, I would urge you to make sure that you legally do searches and legally
Yeesh.
obtain your
Okay.
evidence.
All right. Professional streamer. Jeez.
1968's Terry versus Ohio. An officer doesn't need a warrant to stop and pat somebody down with reasonable suspicion that they are armed or involved in criminal activity. In San Andreas, the vast majority of individuals do have weapon licenses. We are an open carry state. And so cops generally do have the reasonable suspicion that a person may be armed. And a stop and frisk is, let me pat you down. Do you have any weapons on you? Is there anything that could prod, poke, or hurt me? It is not a full, deep search of your pockets or your vehicle. Now, Pennsylvania versus Mims actually expands on that a little bit. If a law enforcement officer is ordering somebody out of a car during a traffic stop, they can conduct a pat down for weapons if they do have reasonable suspicion, again, that they possess a weapon. These two are, I like to think of them as kind of linked up because one of them is like, they don't need a warrant to stop and frisk you. And then Pennsylvania versus Mims is, and they can do it during a traffic stop if need be. Graham versus Connor, the appropriate escalation of force. There is a standard of reasonableness to a civilian's claim that law enforcement officials used excessive force in the course of making an arrest, traffic stop, or other seizure of their person. This is to say that if a civilian is fronting on a law enforcement officer during the process of an arrest and, they're being kind of difficult, they're maybe fighting off a little bit, and they swing on that officer, which is just always a bad idea, the officer does not have the reasonable standard to then, pull out their class 2 shotgun and put a hole through somebody. There is an expected appropriate escalation of force. Obviously, I do believe they match non-lethal with non-lethal and lethal with lethal. Lethal weapons being knives, guns, etc. And non-lethal generally gonna be like your fists or a bat. However, in some situations, they may escalate given, if they do feel somebody is a danger,
Hello, everybody who
which
may have
is
just come
covered
in.
Tennessee
We're
versus
in the middle of
Gardner's
law
fleeing
school
felon.
right now, so
An officer may not use deadly
not a
force
lot of
to
activity,
detain
but
somebody
if
when
it's
they
your
are
jam,
fleeing
it's
unless they have
interesting.
probable cause to believe that the suspect poses a significant threat of death or serious injury to the officer or others. If somebody is trying to flee an arrest and they are really good with the bat and they've already downed somebody, they may end up using that deadly force to prevent their escape because they can believe that the person will injure not only themselves but others around them with whatever weapon they are using. However, if the officer has completed that pat down during the arrest and now the person is running away and they don't have any weapon, maybe they're just like, oh, don't shoot, don't shoot. They can't use that deadly force to detain them. They can tase them, maybe. They can put hands on them as necessary, but they can't shoot. They can't use deadly force. Pretty self-explanatory, I think. Any questions on any of those so far?
Nope.
No, none from me.
Okay, so our final case law we're going to go over here is the Brady disclosure from Brady versus Maryland. In a criminal case, the prosecutor must disclose evidence or information that would prove the innocence of the defendant, enable the defense to more effectively present their case, or that may serve to reduce the defendant's sentence. In a criminal case, if you are prosecuting, you will usually be working with the DA's office or as a public prosecutor through the Department of Justice. And if you find evidence, you must disclose it to the defense. Because people are innocent until proven guilty, and all evidence should be presented. And if it is found that, that evidence is not disclosed, It can be a huge ethical issue. It may even lead to cases being, set up for a retrial with a different judge, etc., etc. Because the Brady disclosure was not observed and the defendant was not given a fair trial. If you are the defense on a criminal case, you don't have the duty to provide any evidence to the prosecution if you don't want to. And your attorney-client privilege does take precedent there. And in a civil case, it's more or less the Wild West. Obviously, we do have the discovery phase, and it's nice if you provide your evidence ahead of time so that the judge can come in with at least some knowledge of, like, what's being presented. And if, you want somebody to review, like, 5 hours of body cam, they have 5 hours. But otherwise, you don't have a duty to furnish that evidence to anybody. And we did discuss the filing requirements and standard of proof for civil court. We discussed the rules of procedure, which brings us to our objection. Okay, argumentative is an objection to be used when the questioning attorney isn't asking a question, they're making a point, and they're like trying to expect the witness to answer that. It's, you didn't ask somebody a question, the fuck are they gonna say to you, bud? And it's not a question that the witness can properly or fairly answer. And of course, you would say objection, argumentative, and the judge would think about it, look over at the questioning attorney, and either sustain or overrule your objection. If you do object to something that is said, especially if the witness has started talking before you can properly object, what you're going to want to do is then make a motion to strike that information from the record. The judge will likely do so if they've sustained your objection, and if we have a jury trial, you would then you would ask the judge to instruct the jury to disregard that information. The judge, you don't have to ask to disregard stuff. We're aware if we strike something, it's not part of the case anymore, but a plain cloth jury would not necessarily be aware of that. Asked and answered: when the same attorney and same witness have already asked and discussed this question, it's redundant, it's asked and answered, self-explanatory. Assumes facts not in evidence. A attorney on direct examination is asking, words are hard, asking a question that is based on information that they have not provided. Either they have not solicited the testimony to make this question make sense, or they have not furnished evidence like a police report, etc., to make it make sense. However, on cross-examination, they can assume facts not in evidence because the counsel is more or less giving their testimony as to what they believe happened in the form of leading questions for the witness. Beyond the scope. So beyond the scope of direct is when during cross-examination, the cross-examining attorney asks a question of the witness that was not covered in direct examination. They're going to want to pull that witness themselves if they want to ask that. And then, of course, during redirect, questions can be asked that are beyond the scope of cross. Pretty simple there. Compound, the question is actually two questions posed as one, and answering one may look really bad because it is a horrible way to answer the other. Would you say that you go to Brahma Mamas frequently, and do you believe that, I don't know, what would it be? It's really hard for me to think of these because I'm usually pretty direct in my questioning. Were you there at the scene of the murder, and do you love your mother? Yes, of course I love my mother. Oh, so you were there at the scene of the murder. It's a compound question, it should be two separate questions. And in a jury trial, it can definitely be misleading. Cumulative. The material being asked has been covered before. We don't normally have this problem because we don't have cases with bolo witnesses, but in a larger case, like in our PDM case, this was an objection that could have and honestly should have been made because the same material was being covered again and again by every witness. Hearsay, which we discussed at length, is a statement made out of court that has been offered in court to prove the truth of the matter. He said, she said again, like, I heard Damien say that Rory told him that Reggie said, like, don't play telephone. If you need somebody's testimony, call them in, not somebody who heard them talk about it to somebody else. Calls for a legal conclusion. Do you think that they were guilty of the crime? That's a question for the judge or the jury. That's not a question for your witness. Improper characterization is when a question or even a witness's answer is highly prejudicial. It uses charged words, maybe with negative connotation. Describing somebody as crazy, a sociopath, a maniac. These words aren't really probative and they're not helpful. And the way, like, it's weird because you also don't necessarily want to use this in a jury trial because then the jury is going to latch onto it and be like, well, if their attorney objected to it, then obviously, there's some juicy shit there. But it's just improper characterization is an answer that is highly prejudicial. And again, if you do object for it and get it sustained, you are going to want to have that information struck from the record. Improper expert opinion is when the testimony involves a degree of skill or expertise as a medical professional, a law enforcement officer, a lawyer, etc. And the witness has not been established as a medical professional through testimony and questioning, or they are not an expert. If I were to call Isaac up on the stand, Isaac, are you a doctor?
No, not a medical doctor, no.
Okay. So if I were to pull you up on the stand and randomly start asking you questions about, how to treat somebody with a dislocated hip, it would be an improper expert opinion if you were to give your answers because you're not a medical professional, you haven't been established as an expert in treating hips, etc., etc. I believe, Damien, you used to work at Pillbox, right?
Yeah, I was an EMS.
So if you were still EMS and somebody pulled you up and they were like asking you about like on-scene treatment for injury, it could be improper expert opinion if they don't establish that you were EMS or that you were working and etc., etc. Even if you pull a cop up on the stand, if you don't establish that they're a cop, that they've worked for the San Andreas State Troopers for whatever period of time, it can still be an improper expert opinion. And this kind of also harkens back to our assumes facts not in evidence or our lacks foundation. Sorry, I'm starting to go hoarse. You're going to want to make sure that you establish every detail of your case as you go on and you don't go ahead of yourself, because otherwise you may not get the results that you're looking for. Okay, now that I've done rambling about improper expert opinions, let's talk about improper impeachment. This is when somebody tries to confuse the witness into contradicting themselves. This is, if they're trying to refer somebody back to something they previously said, but they don't have the actual wording of it, they don't know when they said it, and they're basically just saying, like, oh, well, didn't you say this? And they can't substantiate when that was said. To call somebody out and impeach their statement, either for lying on the stand, perjury, etc. You're going to want to make sure that the witness is not answering their question truthfully or they are forming a contradiction. And it's a simple question. You can even clarify it. You would then refer the witness to the previous statement that they made. If we had a stenographer, you could provide the opposing counsel and the witness with a line number or page to which they're referring. And then you would ask the witness, did you previously say that you were not there at that time? Then the witness would have to clarify or potentially be held in contempt of court for perjury. And of course, their testimony may in fact be thrown out because they've been lying, etc., etc. improper lay opinion. This is the opposite of improper expert opinion. The witness is giving, you know, testimony that doesn't require any expertise, but it doesn't help us understand the case. This is, you know, you pull me up on the stand and we're talking, and I start talking about, you know, I really love the horchata from Casa Latina. I think it's great. I love cinnamon, da 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 da. Talk about like Casa Latina has the best food in town or whatever. And like you're asking me about a murder that had nothing to do with Casa. It is an improper lay opinion. Because anybody can have that opinion, but it doesn't make sense to use here. Lacks foundation. The evidence has not been entered or established that would make the evidence that you're trying to solicit admissible. Proof like of a confession, information on a police report, establishing somebody as a witness, or that a document is admissible. This is the kind of objection where like somebody starts saying some shit and you're like, this is weird, I don't think this is good, and you're not exactly sure how, and you need that time to kind of figure out what the fuck is going on. You can go objection lacks foundation. At the very least, the judge is going to turn to the questioning attorney and be like, can you establish, my guy? And the person is going to have to stop asking the question that they're asking, think about it, and explain, and it's at least going to give you a minute. And you know, if they do object for lax foundation, you can then clarify and be like, sorry, I meant that this was assuming facts not in evidence, this is hearsay, or put more information in that would then get an objection that would be sustained. Really, if you want to do court like an asshole, your lax foundation, your leading, relevance, and occasionally speculation are good objections to make, because they are at the very least going to throw the opposing attorney off of their game. You're going to confuse them. They're going to have to stop their line of questioning in order to deal with you. And it can completely derail them. And in some cases, if they're intimidated, they'll withdraw their question. It can be very effective, even if it is kind of a dick move. Leading is, of course, a question that suggests an answer, and is really only an objection on direct examination. On cross-examination, most of your questions are going to be leading questions. More prejudicial than probative is kind of like improper characterization. The evidence being introduced is highly prejudicial to the client, and it outweighs the probative value. This really hurts the case, but isn't relevant to the other side's case enough to be important. This is Smiles has somehow been released from prison, and he gets a ticket and he brings it to traffic court. The public prosecutor on this has decided that as part of their case against Smiles, to bring up that he is a serial killer and he kills people. Unless Smiles was speeding to a murder, it is not probative to the case, but it is highly prejudicial against him.
Well, I mean, it seems entirely
And of
likely,
course, any
frankly.
defense attorney for Smiles that is worth their salt is going to object that it is more prejudicial than probative and ask to have it stricken. Non-responsive, the witness is not answering your question, or they are not answering your questions straight up, because it is, of course, the truth, the whole truth, and nothing but the truth. If somebody is dancing around an answer, they are being non-responsive. If somebody refuses to answer, they are being non-responsive. And if a witness is non-responsive, you can object to it as the questioning attorney, or even as the cross attorney if need be. And the judge is going to turn to them and press them to answer the question. If they continue to refuse, obviously they are, sworn on the stand, and can be held in contempt of court, and potentially even held until they agree to answer or testify. I've never seen it come to that, honestly. Relevance, the evidence being solicited doesn't relate to the case or doesn't really have a purpose. It's again one of those like easy objections to throw out to kind of throw somebody off, but it's also the what the fuck objection. Like, if somebody is starting to ask really weird questions that don't really apply to the case, and obviously they're probably trying to lead somebody somewhere, but who knows? Speculation, the witness doesn't have firsthand knowledge of it. This is, well, I think that he thought he could get away with it. That's cool. I'm not a clairvoyant. Or thinking about why somebody did something. Or even like the hypothetical, well, if the officer hadn't tackled him, he would have gone off and done 3 more bank robberies. Again, you're not a clairvoyant, you don't have a crystal ball, it's speculation. And that brings us to the end of our curriculum. This document, as well as the resources at the bottom, which include the San Andreas Penal Code, the Cornell Law School site, which has a great free resource, and some Wikipedia lists of legal doctrines and torts, are of course easily available for you to use. There's also a link to our ethics and misconduct guideline, which were you to become a San Andreas state attorney and get your bar and your law license, you would be expected to uphold. There's all the information there. Are both of you interested in taking the bar exam at this time?
Yes, I am.
Yes, indeed.
Great, I will go ahead and email that to both of you. The test is open book, and you can use any of the resources we have provided. If you do have any questions about like the matter of a question or need clarification, you can reach me. I am going to email you both a link to this. Isaac, I don't believe I have your Discordia email.
Oh, sure.
If you could go into the city bulletin board on Discordia and just put, an emoji or something, I will email you a link to this.
Sure thing. I can go do that.
Do you want me to start this as soon as we get it, or?
Yeah, you can start it whenever. Obviously, you'll notice that that copy is not able to be edited. You're going to want to copy down your answers either in a notepad or a separate document, and then you can send your answers to me over government email or Discordia email, whatever works best for you. I will be waiting outside. I don't know, it's a test. There's no other explanation I can give other than, sorry, there are more explanations. I am a little ahead of myself. The first 4 questions, as you'll note, are multiple choice. You can provide just the letter, or you can provide the letter and your reasoning behind your answer. If you do select the wrong letter answer, but you have the right reason, I am more likely to give you half or partial credit for that question. But also, if you don't feel like it, you don't feel like it. You have all of the time in the world to take this exam, but there is about a half hour before the weather passes through. So if necessary, we can take a brief recess because I don't advise... Well, no, I guess you can sleep in here, but you might want to get out of the chair if you are going to. Question 5 is a 3-part short response. I'm going to want, 5 and then like 1, 2, 3. You can provide a sentence or 2 for each answer, whatever you feel is necessary to justify your answer. And of course, I will be just outside if you have any questions, comments, or concerns. Best of luck.
Whew, okay. So we're taking the bar exam. All right. Oh, this isn't so bad. Oh, wow. These questions are literally stacked like bar exam questions. I seriously think these are actually bar exam questions. Wild. Okay, well, I tell you what. Considering the rest of this is literally going to be me making a test, which is not going to be thrilling at all for anyone to watch, I'm going to break the stream here, and then we'll come back after Storm, probably do some hunting, some other things that are actually more thrilling and exciting for this. Than this, I should say. So, I will see all of you in about 30 minutes or so.